Greetings all. This is a heads up on an important legal issue. First, a disclaimer. I'm not a lawyer and I do not provide legal advice. You should consult with an attorney about what I'm about to share. We're seeing the beginnings of a sea change with professional non-compete agreements. President Biden, back in July of 2021, issued an executive order on promoting competition in the American economy. This order encouraged the Federal Trade Commission to exercise its rulemaking authority to diminish the unfair use of non-compete clauses that may, quote, limit worker mobility, close quote. On January 5th, 2022, the FTC published a notice of proposed rulemaking which would preclude employers from entering non-compete agreements with employees. It also would render unenforceable all previously entered non-compete agreements. Currently, the states of California, Nebraska, North Dakota, and Oklahoma have a near complete ban on non-compete restrictions, while other states restrict the use of non-competes in various ways. In addition, over the past several years, more than a dozen states and Washington, D.C. have imposed certain statutory requirements that employers must satisfy to enforce non-competes. These requirements often include a minimum compensation level, as well as notification obligations. If the FTC's proposed rule becomes final, it will prohibit employers from entering explicit and de facto non-compete clauses with employees. A non-compete clause would be invalid if it has, quote, the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. Additionally, the proposed rule applies not only to employees but also to independent contractors, externs, interns, volunteers, apprentices, and sole proprietors offering services to the company's clients or customers. And as of March 1st, 2022, revisions to Colorado's sentencing law created criminal liability for knowingly using non-competes that violate Colorado non-compete law. These criminal penalties will apply to both unlawful non-competes and unlawful non-solicitation agreements. Why is this happening? Well, it's an indication that our labor shortage in this country is not going to dissipate anytime soon. Indeed, relative to optometry, our resources tell us that there are over 5,000 open positions. Is it any wonder why the lawmakers are trying to eliminate this clause that restricts employee movement? But like everything else, there are workarounds to better protect your asset from predatory competition from an insider who's left your team. Knowing what's possible takes experience and investment. My point in sharing this is that so many optometrists and other professionals take a do-it-yourself approach to business relationships and contracting. Hey Bill, can I have a copy of your contract so I can use it for my new associate? Is a question that I know takes place in our industry frequently. And like anything else, as it relates to contracts, what you don't know, you don't know. And in this case, what you don't know can really come back to bite you. At Cleinman Performance Partners, we've managed contracting design and negotiations for decades. While we manage the meat and potatoes of such engagement, we always seek legal counsel for final approval of such agreements. We know the business and optometry nuances, the lawyers know the law. Before you embark on a contract negotiation, give us a call. We're happy to discuss your specific situation and provide guidance.